Chapter 2, Sources of the Law of Crimes, Section 20. The 5 sources of law. In the United States there are 5 sources of law. These 5 sources, in the order of superiority, are as follows. 1. The United States Constitution. 2. Acts of Congress. 3. State constitutions. 4. Acts of state and territorial legislatures. And 5. The common law. If a provision of the United States Constitution conflicts with an act of Congress, the latter is void. If a valid act of Congress conflicts with a provision of a state constitution, the latter is void. If a provision of a state constitution conflicts with a statute of the same state, the latter is void. And if an act of a state or territorial legislature conflicts with a provision of the common law, the latter is void. Section 21. The United States Constitution. The United States Constitution, together with the treaties made in pursuance thereof, constitutes the supreme law of the land. It provides that the trial of all crimes, except in cases of impeachment, shall be by jury, and that such trials shall be held in the state where the said crimes shall have been committed, but when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. It also provides that treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort, and that no person shall be convicted of treason, unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. It further provides that a person charged in any state with treason, felony, or other crime, who shall flee from justice, and be found in another state, shall on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. Section 22. Acts of Congress. Congress has no inherent power whatever. In this respect it differs widely from a state legislature. It has only such powers as are conferred upon it expressly or impliedly by the United States Constitution. Moreover, this instrument contains some express restrictions upon its powers. All legislative powers, however, granted by the United States Constitution, are conferred upon Congress. It has power to legislate not only for the United States as a whole but also for the territories and for the District of Columbia. Section 23. State constitutions. State constitutions differ materially from the United States Constitution. The former constitute, for the most part, restrictions all imitations of powers, whereas the latter constitutes, for the most part, grants of powers. The Constitution of Illinois, which may be taken as typical, in this respect, of most states, contains, among others, the following provisions. No person shall be deprived of life, liberty or property, without due process of law. Every person may freely speak, write and publish on all subjects, being responsible for the abuse of that liberty, and in all trials for libel, both civil and criminal, the truth, when published with good motives and for justifiable ends, shall be a sufficient defense. The right of trial by jury as heretofore enjoyed, shall remain inviolate. The right of the people to be secure in their persons, houses, papers and effects, against unreasonable searches and seizures, shall not be violated. And no warrant shall issue without probable cause, supported by affidavit, particularly describing the place to be searched, and the persons or things to be seized. All persons shall be bailable by sufficient sureties, except for capital offences, where the proof is evident or the presumption great, and the privilege or writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it. No persons shall be held to answer for a criminal offence, unless on indictment of a grand jury, except in cases in which the punishment is by fine, or imprisonment otherwise than in the penitentiary, in cases of impeachment, and in cases arising in the army and navy, or in the militia, when in actual service in time of war or public danger, provided that the grand jury may be abolished by law in all cases. In all criminal prosecutions the accused shall have the right to appear and defend in person and by counsel, to demand the nature and cause of the accusation and to have a copy thereof, to meet the witnesses face to face, and to have process to compel the attendance of witnesses in his behalf, and a speedy public trial by an impartial jury of the county. or district in which the offence is alleged to have been committed. No person shall be compelled in any criminal case to give evidence against himself, or be twice put in jeopardy for the same offence. All penalties shall be proportioned to the nature of the offence, and no conviction shall work corruption of blood or forfeiture of estate, nor shall any person be transported out of the state for any offence committed within the same. No person shall be imprisoned for debt, unless upon refusal to deliver up his estate for the benefit of his creditors, in such manner as shall be prescribed by law, or in cases where there is strong presumption of fraud. No ex post facto law shall be passed. Section 24. Acts of State Legislatures. State legislatures, unlike Congress, have inherent power to declare acts criminal and to impose penalties for their violation. Their power, however, in these respects, is not absolute. Their enactments must not conflict with any provision of the United States Constitution, or of the state constitution, or with any valid act of Congress. Barring these limitations, however, their legislative authority is absolute, and their enactments, when they become law, must be enforced by the courts. It is the province of the legislature to determine in the interest of the public what shall be permitted or forbidden, and the statutes contain very many instances of acts prohibited, the criminality of which consists solely in the fact that they are prohibited, and not at all in their intrinsic quality. The unnecessary multiplication of mere statutory offences is undoubtedly an evil, and the general interests are best promoted by allowing the largest practical liberty of individual action, but nevertheless the justice and wisdom of penal legislation, and its extent within constitutional limits, is a matter resting in the judgment of the legislative branch of their government with which courts cannot interfere. Section 25. Acts of Territorial Legislatures. Territorial legislatures are created by Congress, and their powers are limited to those conferred upon them by that body. Their legislative power shall extend to all rightful subjects of legislation not inconsistent with the Constitution and laws of the United States. Section 26. Acts of the British Parliament. The British Parliament, like state legislatures, has inherent power to declare acts criminal and to impose penalties for their violation. Unlike state legislatures, however, its hands are not tied by any written constitution. Its power to enact laws, therefore, is absolute. Section 27. The English Common Law. The basis of the English Common Law is immemorial usage and custom, and not legislative enactment. For this reason it is often called the unwritten law. The generic term common law has been well defined as those maxims, principles, and forms of judicial proceedings, which have no written law to prescribe or warrant them, but which, founded on the laws of nature and the dictates of reason, have, by usage and custom, become interwoven with the written laws, and, by such incorporation, form a part of the municipal code of each state or nation, which has emerged from the loose and erratic habits of savage life, to civilization, order, and government of laws. The authority of these maxims, and rules of the common law, rests entirely upon general reception and usage. Section 28. The American Common Law. The American common law is similar in most respects to the English common law. Insofar, however, as the latter is inapplicable to our conditions and surroundings, it is not a part of our common law. On the other hand, it includes some usages adopted by the colonists, some English statutes in force when they settled in this country, and a few enacted afterward and before the Revolution. The Supreme Court of the United States has decided that English statutes which were enacted before the emigration of our ancestors, and which were in force at that time, and which are applicable to our conditions and surroundings, constitute a part of our common law. Section 29. The common law as defined by legislature. The common law of many states is expressly defined by an act of the legislature. The Illinois Act, which is practically the same as that of other states, provides that the common law of England, so far as the same is applicable and of a general nature, and all statutes or acts of the British Parliament made in aid of, and to supply the defects of the common law, prior to the 4th year of James I, excepting the 2nd section of the 6th chapter of 43d Elizabeth, their 8th chapter of 13th Elizabeth, and 9th chapter of 37th Henry VIII, and which are of a general nature and not local to that kingdom, shall be the rule of decision, and shall be considered as of full force until repealed by legislative authority. The 4th year of James I began on March 24, 1606. Criminal offences, not defined in the Criminal Code of Illinois, are punishable under the common law. In some states there are no criminal offences except those expressly declared by statute. In the absence of evidence of the contrary, the courts of any state presume that the common law prevails in the sister states. Section 30. Mode of determining the common law. The common law of England may be found by reference to the decisions of the common law courts of that country. Judges are bound to resort to the best sources of instruction, such as the records of courts of justice, well-authenticated histories of trials, and books of reports, digests, and brief statements of such decisions, prepared by suitable persons, and the treatises of sages of the profession, whose works have an established reputation for correctness. Among the sages of the profession whose works have an established reputation for correctness are Coke, Hale, Hawkins, Foster and East. Stevens says, somehow, no one can say precisely how, certain principles came to be accepted as the law of the land. The judges held themselves bound to decide the cases which came before them according to those principles, and, as new combinations of circumstances threw light on the way in which they operated, the principles were, in some cases, more and more fully developed and qualified, and in others evaded or practically set at naught and repealed. Thus, in order to ascertain what the principle is at any given moment, it is necessary to compare together a number of decided cases, and to deduce from them the principle which they establish. It is to be observed that it is not essential that the facts of the case in question be on all fours with those of a decided case. The analogy between them may be sufficient to justify the application to the former of the principles established by the latter. 31. Section 31. Importance of the common law. The great importance of the common law is sometimes lost sight of. However, it constitutes the basis of instruction in all the leading law schools of the country. The reason is, that the common law is the foundation of our legal system. To a very great extent, the unwritten law constitutes the basis of our jurisprudence, and furnishes the rules by which public and private rights are established and secured, the social relations of all persons regulated, their rights, duties, and obligations determined, and all violations of duty redressed and punished. Without its aid, the written law, embracing the Constitution and statute laws, would constitute but a lame, partial, and impracticable system. Even in many cases where statutes have been made in respect to particular subjects, they could not be carried into effect, and must remain a dead letter, without the aid of the common law. In cases of murder and manslaughter, the statute declares the punishment, but what acts shall constitute murder, what manslaughter, or what justifiable or excusable homicide, are left to be decided by the rules and principles of the common law. If an act is made criminal, but no mode of prosecution is directed, or no punishment provided, the common law furnishes its ready aid, prescribing the mode of prosecution by indictment, there. Common law punishment of fine and imprisonment. Indeed, it seems to be too obvious to require argument, that without the common law, our legislation and jurisprudence would be impotent, and wholly deficient in completeness and symmetry, as a system of municipal law. Section 32. Abolition of the common law. In some states, including Ohio, Oregon and Minnesota, all common law crimes are abolished by statute. In several other states, including Michigan, Iowa, Indiana, Kansas, Texas, Nebraska and Oregon, no act is a crime unless so declared by statute. But in these states the principles of the common law are applied in construing the statute. In other words, the statute may limit the description of the crime to its common law name, in which case the principles of the common law may be resorted to in determining what acts are essential to constitute the crime. In most of the states, however, common law crimes have not been abolished. In a state which has a criminal code, but which has not expressly abolished common law crimes, like Illinois, a common law crime not covered by the code is still punishable. Section 33. Federal courts have no common law jurisdiction in criminal cases. Under the United States Constitution, the federal courts have no jurisdiction except that conferred upon them by Congress. To render an act punishable as a crime against the United States, Congress must declare it a crime, affix a penalty, and declare the court which shall have jurisdiction of the offense. It follows, therefore, that the federal courts have no common law jurisdiction in criminal cases.